So when it comes to DIYing your estate plan, there's a lot of things to consider. While the cost may be less for you right now, it doesn't always mean that it's going to be less in the future. I have seen many cases over the years where people have done DIY plans using some type of digital online platform, and they have that false peace of mind thinking that I have my estate planning done, there's nothing that I need to do, my family's protected. And in the cases that I've seen it where a father had told his son, and he had probably about $2 million in assets, that he had completed his plan, and he did. Dad died, and the son brought the trust to me. I reviewed it, and guess what Dad forgot to do? He forgot to sign it. Therefore, his trust that he had, this peace of mind thinking was complete, and he told his son that it was done, was not, because it was not signed in a valid way for the state of California. Therefore, his $2 million estate that he thought was in a trust, we had to go through probate court, and it ended costing them thousands and thousands and thousands of dollars, upwards, I think, of $40,000 to actually go through probate court for this $2 million estate. And it was the frustration and the stress that the son had talked to Dad and said, Dad, I need to make sure that this is done. We need to make sure that everything is very clear with your wishes. And unfortunately, it just wasn't done correctly because he wasn't working with a professional. This can all be avoided by having it done with a professional. I had a client that came to me after his father had passed away, and he had done a DIY will for his dad online. His dad was very sick. He was acting in just an abundance of caution to try and get something in writing. And when he came to me at this point, his dad had already passed away. I was reviewing the will, but the will was not executed properly. So in California, we have very specific requirements when it comes to a will being valid. And in this case, it was an online form that they had used, just filled in information. And when it came to the signatures, Dad signed the will, and then they had it notarized. The problem with that is, in the state of California, a will has to be witnessed by 2 people. So the notary that witnessed the will was one signature. They were missing that second signature. Therefore, the will was invalid. Right? This is why working with an estate planning attorney is so important, because it ensures that whatever the qualifications are, whatever those requirements are able to be met to make sure that you have a plan that actually works when you need it. I had a client whose sister passed away, and she was in her 80s when she passed, and her sister was just a little younger than her, and she was so sweet, and such a sad situation. When she brought the will to me, the will was in a little notebook that she kept by her nightstand. And it's where she actually had her grocery list. And that's where she wrote her will. And in California, we call this a holographic will. So it was all in her handwriting. It was dated. She said how she wanted her estate distributed to her sister, and she signed it. So in California, this is a valid will. We had to go through probate. She did own some property, and her estate was of the level because she had a will. She didn't have a trust to avoid probate, so we had to go through probate court. During this probate process, we have to publish, right? Publish notice of the passing. So I get an email from the son of the deceased, who I did not actually knew existed at this point. And he was estranged from the family for more than 60 years, and at this point, he is now the beneficiary of this estate. Because this will was holographic, and because she did not work with an estate planning attorney, she did not have the required language in a will to say, I have a son, but I have not cared for him specifically in this will. And because he was left out of that holographic will that she wrote, the idea here is that he was omitted. And the reason for it is because, maybe she thought he had died, and she didn't know that she needed to care for him. So he had a valid claim to this estate. We were able to settle this case outside of probate court, and he got a very large settlement, but it was an unfortunate situation that he got any money at all, given the situation that happened with the son and the mom. If there's any question at all, please work with an estate planning attorney. We are here to help you to be able to make sure that whatever your family situation is, we can put it legally in writing the way that you need it. Oftentimes, we get clients that come in that maybe started a DIY plan on their own, and they come to us already paying the money for the DIY plan and in a state of they don't really know what to do next. It was confusing. They didn't know what the terms meant. They didn't know who to choose in these positions. So if you are at the point that you are trying to figure out, how do I get started with my estate plan? Consider not doing a DIY plan, but working with a professional, because you're paying for their experience and their counseling on being able to have conversations, answer those tough questions, and explain things so that you can tell us what your wishes are, and we can put it legally in writing to make sure that we're accommodating your wishes. It's the worst thing that I see is when a client has already spent all this money trying to do something else, and then they end up coming to us anyways. Don't be in that situation, and just start with us from the beginning.